Dr. Pasquale is an expert on the law of artificial intelligence, algorithms, and machine learning. He has been recognized as one of the 10 most cited scholars in health law in the United States. His book, The Black Box Society, The Secret Algorithms That Control Money and Information, develops a social theory of reputation, search, and finance. The Black Box Society has been reviewed in Science and Nature and published in Chinese, Korean, French, and Serbian translations. Dr. Pasquale has been recognized as one of the leaders of a global movement for algorithmic accountability and co-organized one of the leading conferences on the topic in 2016. In media and communication studies, he has developed a comprehensive legal analysis of barriers to and opportunities for regulation of internet platforms. He keynoted the German Republica conference in 2017 with a talk on the automated public sphere, and the Canadian Data and Power conference in 2017 with a talk on how law and policy may shape the future of journalism. In privacy law and surveillance, his work is among the leading research on regulation of algorithmic ranking, scoring, and sorting systems, including credit scoring and threat scoring. Please welcome Dr. Frank Pasquale.
Well, it is just so great to be here, and thank you to Wentao. I just had such a great series of conversations today with students, with some of your CS professors, with Professor Andreevich, and it's just been so educational for me today. And so I hope I can return the favor by illuminating some of the darker corners of our reputation economy. And just to frame what I'll be talking about, because I'm going to drive into some of the more concrete examples in a bit, but what I'm really trying to illuminate here is something that I'd call like the reputational economy of cyberspace, which is to say that on top of or parallel to an economy of money flows and people becoming wealthier or becoming less wealthy and other sort of monetary flows like that, there's also a reputational economy. And each of us has sort of a digital doppelganger, a digital double out there in this reputation economy. And it's accumulating points and demerits. It's accumulating sort of visibility or obscurity. And the processes whereby that is happening, I think we need to uncover as a site for legal action, okay? And I think what's really critical here is that throughout history, and speaking, as a law professor coming from law school, a lot of the history of law is the history of people suddenly realizing that an aspect of life that was totally unregulated and private and secret needed regulation, right? So a lot of times, for example, you had in the 1960s and 70s relationships between women and men in the workplace. They were just seen as like, well, boys will be boys. If there's something going on where men are mistreating women, doing other terrible things to them, well, that's just the workplace, and then you can leave if you want to if you're a woman. However, thanks to a lot of legal scholars, we recognize now sexual harassment as a cause of action, right? People like Catherine McKinnon, other activists. We've recognized that there actually has to be legal action here to structure the power relationships within the workplace so that people are not taken advantage of. And those structures help everyone, right? They help everyone, I think, trying to make the workplace a better place. And I want to say that, by the end of the talk tonight, what I hope y'all will agree with me is that there are so many unregulated data flows, so many ways in which our reputation is either being hurt or damaged by unregulated data flows, that we need a lot more legal attention to this space. So that's where I'll be going tonight. Now, just thinking about, where's all this information about us going to, right? This is a very schematic representation that the Federal Trade Commission developed in 2012, I believe. So this was a 2012 representation by them talking about these different sectors. You go into the retail store, airlines, credit card companies, they're looking at what you're doing. There's public agencies that have information. There's the internet, there's medical groups, there's finance and insurance, telecoms, and mobile. In American privacy law, we pay a lot of attention to what the government does, and we have a lot of even constitutional level protections thanks to the Fourth Amendment. But those protections have become, in many respects, a dead letter, because all the stuff that's being done in all the other 5 areas can be purchased by the government, right? So much of the ways in which government is restricted, we have a law that says, well, you can't do X, you can't do Y, but then they just go and find a private data broker that does this. That private data broking business is massive. There's just thousands of firms out there that are accumulating this information. And by the way, the government intelligence sector, we can't underestimate that either. According to a series called Top Secret America, I think it's still up on topsecretamerica.com by Arkin and Priest, there's over 1,100 intelligence agencies of the U.S. government. Kind of astonishing, right? 1,100 agencies, all with potentially hundreds, thousands of people. So these are all the initial data flows that are going out there. And in each of these areas, what's also interesting is that as big digital companies get more and more data, everybody else feels like they need it. So for example, and we think about retail stores, there's a new book called The Aisles Have Eyes, and it's about the use of facial recognition technology in retail stores. And what these stores say is, look, if we're competing against Amazon, who knows everything about what someone has done online, their whole click stream, we need to basically have facial recognition tech so we could take a picture of your face, match it to a database, get your name, match it to the files that are in those 4,000 data brokers files, and then find ways to pitch things to you, right? And this is sort of the upward arms race of data collection that is happening right now. It's seen as a commercial imperative by big business to have as much data as possible. And one thing that we should think about a bit towards the end of the talk or in the Q&A is, how do we stop that arms race? Can we stop it? Is there any way to do that? Or do we feel that essentially there's just always going to be more and more data collected, stored more efficiently, processed by more people, and we have to regulate that? So that's a big question for the future of the data economy. Now, once you get all these initial 6 sectors that are gathering data, then it starts going out to other groups that are collecting the data and analyzing it. So for example, you might have healthcare analytics firms. Now, a lot of folks think that healthcare analytics, they might just identify that with the healthcare companies themselves, or doctors, insurers, or doctors, hospitals, and insurers. Those are the entities that are covered by HIPAA. But there are all of these entities that are gathering health data or health reflective data about people, like how they walk. Do they walk fast and like this, or do they walk with a slow gait? Things like that. They can gather all these sorts of data and make inferences about someone's health. Okay, so that's going on by these health analytics companies. And the hottest thing right now in healthcare is to combine data from the different sectors to predict risk of readmission or risk of medication noncompliance by people. So for example, one hospital chain in Philadelphia found out that people with low credit scores were more likely to be readmitted to the hospital thanks to, they were more likely to be readmitted to the hospital. They don't know why. I'm sure we could all conjecture some reasons why. But they use that data to predict things about them. And I'm going to go into some more intimate details about this healthcare data profiling in a bit. Similarly, with respect to websites and the information brokers and others, these are like the entities that you might find with like Cambridge Analytica, right? So we've seen all of the news about Cambridge Analytica, how they essentially had this quiz that when Facebook in 2012 had a rule that you could download your friend's information if that person signed on for a quiz, and then they could bring on the information from all those people around them. That's all floating around out there, all potentially repurposed in various ways, right? Now, ostensibly, Facebook had an agreement with those companies that they would only use that data for limited purposes. They were required to do that by the Federal Trade Commission, this federal entity in the US. But even at the time, a guy named Sandy Parakilis, who was an internal whistleblower, said, we have agreements with other companies about this data flow. For example, say, imagine it was going from Facebook to different developers, but we don't know, we don't audit them. We don't really take precautions to secure the data once it gets out. And the top management in Facebook at that point said, be quiet. We just want to bring more developers on. The more developers we bring on, the more profits we'll have. Okay. And so the question now the government faces is, do they punish Facebook for that or not? Right. And my answer, to predict is probably they're going to say not. But, or they're going to do a very small job of it. They're going to do a very small fine. And that's something we also need to change in the attention economy, because we can't have rules where if the rule are set forward to control data flows, if you break them, there's no penalty for that. Then that's just the government telling people break the law, right? And there's actually a book I would highly recommend if you're interested in like tech companies and their political and economic consequences. Very accessible book by Scott Galloway called The Four, okay, about Facebook, Apple, Amazon, and Google. And that book describes why these companies so often break the law. It's because the penalties are pretty minimal, right? And that's, another part of another story we could tell about a two-tier justice system, where there are some people that are subject to the law in excruciating intensity, and others for whom it just is a minor inconvenience. So that's a problem with our data economy. Now, moving on in terms of personal consumer information in these forms, all of this data eventually gets used by these entities that then it flows back and affects the person, right? So you have, for example, any of this data could be used in credit granting, right? Credit for debit cards, mortgage, etc., insurance, health, automobile, or life, retail coupons, all these things. All of these different areas have different types of law, and the law often gets very complicated. So, for example, with life insurance, almost anything is fair game, right? It's quite remarkable with life insurance. There was something, though, a recent controversy in New York, where a doctor, was gay and had applied or he had put on his form that he was using, one of the drugs he was using was Truvada, which is like a PrEP therapy, which is essentially a prophylactic against HIV. And when the life insurance company found out about that, they actually denied his application for life insurance, which is entirely perverse, right? Because this is someone who's taking steps to protect his health, but then being punished for that by the life insurance company. And that's an example where this data can sort of get out of control and can lead to discriminatory classifications. Fortunately, because he's in New York, the New York Division of Financial Services is going to go after that firm. They're going to go after that life insurer and say, you're only doing this, the fact that you're doing this is evidence of anti-LGBTQ discrimination, right? But if you were in another state, that may not happen. So it's really important to know the very fine details of legal schemes, because in some states protect people, some don't. Some areas are very protective, others are not. Health insurance, for example, very protected area, thanks to the Affordable Care Act. But right now, the Trump administration is in creating loopholes in the law under the Affordable Care Act to allow what they call multi-employer welfare association plans to basically do medical underwriting, right? So the other lesson here is that even when we think we've won a battle, for example, against pre-existing condition limitations on someone's insurance, like saying that someone can't have insurance because they were sick before, there are always efforts to undo that later on, right? So this is part of the battle over data. These background investigations by employers or landlords are also fascinating. And what's interesting about the employer thing is sometimes the employers are giving people scores based on things like their voice, okay? Not what they say, not even sort of how they say it in a way that we could humanly understand, but big data processing of the voices of the people at the company that are the most successful, and then does your voice sound like those people, right? And you can think of many ways in which Kathy O'Neill, in her book Weapons of Math Destruction, talks about how this is a way of just sort of replaying the past into the future, right? It's strange. And it's also a way in which we're denying people a certain level of agency, right, to prove themselves. It's like if you're just going to be judged on your voice, or if that's even a big variable, it's a strange thing to do. And it's a strange way to sort of reshape how commerce is happening. In China, this is an area where what's fascinating is in all these earlier ones, most of the time, or many times, there are many data sets that get anonymized, or they're used by companies. And so they're not really, it's not like one person buying data about another person. However, the newest trend now is the ability for you to buy data on your friends and acquaintances. Okay, so this is, for example, in data sales in China. For about $100, reporters were able to get a full history of all the hotel rooms a person had, airline flights taken, the internet cafes, border entries, apartment rentals, real estate holdings, right? And there was actually a Chinese artist that just got the records of 600,000 people, and just for the kicks of it, displayed them in a big hall. And just wanted to randomly see like who would know who and who would call each other and who would use the data to go after someone. Now, there's a piece that was recently published by a guy that I mentored named Ted Rostow that was about the possibility of this type of dossiers being available for personal use online in the US eventually, right? And one of the things that's so fascinating about this, when you think about privacy, is this obviously seems very violative of privacy, right? I mean, imagine, you go on a date with someone and the next day they're like, oh, I see that your parents have a great house in Cape Cod. What time, when do we get to see that or something? Or something, or even if they looked at this sort of, or said, oh my goodness, how did your grades last semester? What was happening there, etc. So and I mean, this is really like I think a very chilling future, right? And I think there are some people though that believe that a fully transparent society, like in that novel, The Circle, would incentivize people to do better and better and to do more and more, etc. But I really don't agree with that. I think that's actually quite a frightening future. And I think that our humanity really depends on some ability to keep opinions, facts about ourselves, other things private, or at least to decide how we sequence disclosure of them, right? We have complex personalities, and to just be sort of exposed immediately on all axes of our individuality, I think is quite a threatening thing. And I think we need to think about restricting it. But one problem with restricting it in the U.S., the problem with restricting it in China, and are some efforts by the Chinese government to crack down or to limit the use of certain data, but the issue in terms of the U.S. is that this type of data, when companies are pressured for creating these dossiers and making them public, they defend themselves with the First Amendment. And they say, for example, I have a First Amendment right to say that John is going to get sick and die within 3.2 months. That's my speech. I'm speaking about him. I haven't done anything to hurt him. I've just said he's going to die in 3.2 months. Other people may make a decision about him, but it's not my decision. So this is a very interesting thing, right? And I would love to connect this at some point to some of the campus free speech debates that go on, because it shows how free speech can be appropriated by powerful folks to do some pretty nasty things, right? If you say that, making available in public every bit of somebody's dossier is part of your free speech rights or part of your rights as a scientist or inquirer or researcher, that's quite a dark interpretation of the nature of free speech, and I think a perversion of its ultimate democratic and autonomy-enhancing goals. But that's going to be a huge thing. And I have an article called Reforming the Law of Reputation, where I talk about how we could stop this. But I think we're kind of like one or two votes from the Supreme Court away from First Amendment jurisprudence that would basically say you can't restrict this stuff. Quite chilling. Now, thinking about it, in terms of the actual data flows and what it's used for, this is just one example of, all the different types of entities that could get information about you, say if you get a prescription or other things like that. And one of the things I used to use as an example in terms of prescription data is, and it really is a good lesson about how this type of data can be misused or used in unexpected ways, is that in the mid-2000s, there was a group of doctors and hospitals who said, we need to have really good records of everybody's pharmaceutical records because if, say, someone ends up in an emergency room, we can recall that information and know immediately what drugs they're on and therefore not give them drugs that are contraindicated or that would have a drug-drug interaction, right? It turns out that that was not really implemented very well. That public-spirited thing did not really get much traction in the 2000s. What did get traction, though, was a type of pharmaceutical database that was used by insurance companies to blackball people for their insurance. Okay, this, again, is before the Affordable Care Act, right? The Affordable Care Act says you can't deny people insurance on the basis of pre-existing conditions, including what drugs they take. But this database was used by numerous insurance companies to simply deny insurance to people that took SSRIs, like Prozac, selective serotonin reuptake inhibitors. And so this is quite chilling, right? Because when you hear sort of stories about data being used for good, we should encourage that, but we need to have a legal infrastructure that stops the bad uses or the misuses, right? In this example, you have aggregate statistics, that's great. So the personal profile data flow to the health insurance company could be more problematic, right? But a lot of health insurance companies are saying that they're trying to use that personal profile data to improve healthcare for individuals or to spot people who might need special outreach. So it's complicated. There's lots of good things going on, lots of bad things, but I think law is needed to separate those two. Now, here's another example of like who's creating our reputation. And it's very interesting here to again think about this combination of lots of different information to one company. So for example, there was this one company that sort of contracted with the CIA and other counter-terror groups, and their name was, sorry I got cut off from the slide, but the name of the company was called Recorded Future. And the idea was that you could sort of predict who would be a terrorist and who would not be by virtue of looking at what they post on Twitter, looking at other data they might have, looking at data from websites, which websites are they looking at, which not, and then you could score people for that sort of thing. And that was also shared with entities like the State of Alabama Fusion Center, which was, protecting Alabama from terrorism. That was their ostensible purpose. But then that was quickly repurposed into law enforcement goals. So one of the things that, again, is a theme here is that we're promised, for example, by data brokers and collectors that they're going to use data for one purpose, say anti-terrorism. But what often ends up happening is it gets used for lots of other purposes. The big concern of the Alabama Fusion Center eventually became child pornography, which is a huge problem. But we did not make the decision as a society to have things like all this different sources of data going to fusion centers for that. We did it to stop terrorism. And so this mission creep is another huge problem with respect to data flows. Now, in terms of health predictive information, it's fascinating to look at the different types of subscriptions that can be used to predict someone's health or status, right? So that's like magazine subscriptions, and I know that's an old school example, but replace it with any website you visit online, right? With respect to credit card records, there's already evidence that 1 or 2 credit card companies have used marriage counseling as evidence that someone is going to go through financial distress. So they reduced their credit limit and they increased the interest rate. And I find that very troubling for a number of reasons, right? I mean, it's not as if these folks are trying to actually help themselves, right? People who are going through a bad marriage and get counseling, they should, if anything, be rewarded for that, right? But from the perspective of the credit card company, they only care about correlation. They don't care about desert or the morality of the situation, right? And that's another area where law could help, right? So for example, in law, in a tort case, let's say that I were to go down the stairs and there was no railing and I fell off the stairs, okay? If the landlord who owns those stairs later puts up a railing, I can't in my court case say, look, there's evidence there should have been a railing. The landlord put up a railing after I fell. That's called the law of subsequent remedial measures. Because the law says we can't penalize people for doing the right thing in the courts. That would be counterproductive. And I think we need a very similar type of law with respect to certain data classifications, right? And again, right now, this type of determination is seen as commerce. When I bring this up to the data brokers, when I bring it up to your sort of centrist, technocratic people in Washington, et cetera, they're like, that's business. It's just business, man, But to me, it's not fair. And it deserves to be treated as something like a juridical, a judicial, a quasi-juridical determination that should be subject to some level of moral scrutiny and should encode our moral values, And that's important because a lot of times people that have a tough time, say in their marriage or other areas like that, they're going through a lot. And then if you compound their misery by raising the interest rates they have to pay, then they're under more financial stress. Financial stress probably causes more marital stress. The marital stress may cause them to do badly on their job, and they may fail at their job. It's like these are called doom loops, vicious circles and doom loops. And we have to be very cautious about the way in which, when we use this sort of predictive analytics about bad things that happen to people, that we don't just enter them into a doom loop, right? Because that could be, and that's where data becomes a self-fulfilling prophecy. And that I think is really critical here, is that all of our big data analytics, if we don't use them carefully, could become a self-fulfilling prophecy, and that I think is very, very bad. In terms of internet groups, there are things like patients like me that suffered a scraping attack. So far I've been talking about legitimate uses of data. Sometimes there's totally illegitimate uses, like a scraping attack where they just copy it all off. There's Facebook-based groups where there are all sorts of Facebook groups about mental illness, like National Association for Mental Illness. And people just don't realize that there is a company out there called Social Intelligence that will scrape all public Facebook posts and keep them a dossier on people for 7 years. And by the way, they agreed to 7 years with the Federal Trade Commission. Is anyone auditing that? I don't think so, right? I think it's there forever. And I think if they tried to force them to erase it, they might also bring out the First Amendment and say, oh, we have this First Amendment right to keep this stuff forever. So the stakes are very high, right? And I think for some people, it's enough to drive them off of some social media, right? And I think that's a totally legit response. But on the other hand, there's people that can't go off for various reasons. And so we have to try to help them. your medical reputation. Other things that sort of come out are that you have insurance companies that have access to applicants' prescription histories, companies called MedPoint and IntelliScript. They have all this information on dosage, refills, possible conditions you can extrapolate from them. So again, just lots of privacy violations there. Unclear to what extent HIPAA helps these people at all. And another thing is, going from credit scores to health scores is that you have a lot of information out there now that predicts how much people will cost an insurer, right? And part of the business here is that the federal government tried to risk adjust. They tried to pay insurers based on how sick the people are who are part of their plan. But again, it's very easy to imagine various ways of this being repurposed in troubling ways. One of the things that, in terms of these potential health uses of these things is that, a lot of employers, what's odd about employers in the US is that under a law called ERISA, the Employee Retirement Income Security Act of 1974, we encouraged a lot of employers who are especially large to become self-insured. What that means is that when you buy insurance from your employer, they're on the hook for your sickness. Okay? It's not like they're paying an insurer to take on the risk of you. It's actually U.S. federal government policy to get health insurers, to get employers to take on responsibility for their employees' health. Okay? And that's why there's been so many wellness programs out there. I don't know if has anyone been part of a wellness program? Yeah. So, and these wellness programs are sort of, some of them are kind of funny. Some of them are they try to insurance people, but I mean, what was your experience of it? Did it seem like a good idea or not really? I loved it. You loved it? Good. And why was it so good? That's awesome. That's great. That's very good. And there are good ones. There are good ones out there, right? And I think when you have a good employer, you can have a very good version of the wellness program. But there are also ones that are a little less, that are troubling, right? Or that somehow that really ask. I was part of one, for example, with the University of Maryland, and they had us all do a 30-question psychological profile. And one of the questions they asked was on a scale of 1 to 10, how would you answer this question? My partner and I are closer together than ever. Okay. And I sort of, many intrusive questions like that. And I was like, do I really want the wellness vendor to be analyzing if I may have a problem with my partner, et cetera? And I think that this is a problem where this collapse, it's a problem of context collapse, where because of the weird way we set up health insurance in America, our employers are often providing the insurance and on the hook if we're sick, so they're trying to manage us, but are they doing that well or badly? It's hard to tell. There's other ones where it's people had to sign laughter cards that they laughed at least 10 times a day because that had some sort of positive effect, I guess. And so there's so many variations of these things. But the bottom line of them is that, you have so much economic pressure to know as much as possible about people and to pressure them to act in certain ways. And at what point do we sort of call a stop, and say, this is too much, I also think that, on dating sites, life insurance, all these sorts of things are sort of uses of this data that I think could be quite troubling and could really, but that we've already seen very troubling uses, and it's just going to go further. Another thing that I think is really important to think about is the unraveling dynamic. And this is one where I don't know if people have experienced this here, but imagine when an employer gets resumes from people applying for jobs, and at first nobody puts their GPA on. Then 10% put their GPA on. Then 20% because they feel we got to compete, and if I don't put on my GPA, it's discrediting. Eventually, you get the sense that as an employer, if they don't put on their GPA, then there's something suspect there. Okay. And this is known as a dynamic called unraveling, whereby you can set in motion you either if you don't disclose, people assume the worst about you. And there was an example in a city in Mexico, this Hoyos retinal scan. The company said basically its business model was eventually we're going to have people get the retinal scan and that'll give them privileged access to things. But eventually if you don't have the retinal scan, you just won't get access to things, right? And that is sort of one of the ideas behind I think the Chinese social credit scoring system, right? And behind a lot of credit scoring systems is the idea, if you don't put first, it just is like a bonus and a plus, but later it becomes a penalty. And that I think is a very important dynamic for us to watch out for, is where are these unraveling dynamics happening are there ways to stop them? Are there ways to make sure that they are? Because you could also imagine, given in the future with respect to self-insured plans, that if they're not stopped directly from discriminating, people can try to get ahead of others by disclosing more about their health, their DNA, other things like that. Now, here's another example of uses of data, and I wanted to sort of compare two uses of data. And one is this thing called Project Durkheim, which is called automated flagging for psychological health. This, by the way, this sort of research is now used by Facebook to look for people that might be suicidal. Okay. So what they did was they had data about the people who had returned from wars who were suicidal, and they had data about their social network suicidality data, and they would try to find out whether people who came back from the war were at risk of being suicidal, right? But the good thing about and that on one level might seem troubling to folks, but on the other hand, it's a very deep social problem, and they had people opt into the program, right? They didn't just put people in automatically. You had to opt in, and when you opted in, it wasn't like it automatically affected you. You were referred to an expert for help, right? So this is one way of big data, which I think is pretty commendable, but we can discuss it later on. Oops. But there was another approach that was developed by a company called or a nonprofit group called Samaritan's Radar. And what they did was, if someone tweeted in a way that seemed to suggest that they were despairing or hopeless, Samaritan's Radar would automatically send a direct message or tweet to their friends saying, please, you might want to help your friend. They seem to be in despair. Okay? And that was something where people felt like, this is really troubling because who knows, I might have been joking, right? It might be like, oh, just kill me, after watching the latest Trump escapade or something, And it's just a joke, right? And that's something that natural language processing is often really bad at picking up, is joking, context, other things like that. And so that's an area where in America that could still keep going on, but in Europe, there are laws against certain forms of data processing without consent. So in Europe, they just shut it down, right? And that's going to be a huge difference between Europe and America. And I predict that they're actually, in terms of the grand big picture of things, I think that China is going to really be a vanguard of a lack of privacy. Like if you look at the social credit scoring system, that seems to be part of the general central plan for like the economy from 2014 to 2020, is to replace trust in society by a sense that you're always watched. Because if you had a sense that like if you were always watched on television all the time, you certainly would get a lot of social harmony out of that, wouldn't you? Right? I mean, people would be a lot more polite perhaps, and there'd be so much pressure because you could always lose some points on your score. But there's a lot of, it seems as though it's just too conformist in many ways and too oppressive because it's all controlled by one sort of central party apparatus. And just in general, it's violative of privacy. Europe, I think, will be on the other extreme. I think Europe is going to have so many laws that are protective that you're going to have the very highest standards of privacy there, particularly because the data protection authorities in Europe can fine companies 2 to 4% of global turnover. That would look like a $2 to $4 billion fine for something like Google or Facebook for everything they do wrong, for any particular thing that they do wrong, right? That's a huge incentive to behave, right? That really will change things. And the US, I have no idea where we're going to go. Things don't look bright, but we exist in this sort of odd space in between right now. So yeah. Here's another example too, machine learning for diagnostics or decision support. And this shows the importance of context, I think a slide like this. Facial recognition software may eventually support depression screening, right? You get enough pictures of someone and you sort of see their faces and you can match them up to the depressed or the non-depressed people. And that may be part of electronic health record systems that will use this type of information to tip off doctors that, hey, maybe you should ask them a few more questions that are depression screening as opposed to a few less, or things like that, right? Now, this is part of a big move by experts in healthcare to add social determinants of health and behavioral determinants of health to our way of understanding people, right? But on the other hand, one of the things that I'm trying to argue in recent papers is that people should have the right to opt out or should be required to affirmatively opt in to facial recognition for depression screening. I don't think it's something that should just be rolled out to everybody. But one interesting question we might have as a society is, if we knew or we could surmise that 5, 10, 15 more lives a year could be saved by this automatically being rolled out, would we want it? Or would we feel that consent is important enough that we want people to affirmatively opt in, right? That's a very tough question, I think, in privacy law and law in general. The other thing, though, I would say is that, if you turn this program into something that, say, is being used to look for criminals or being used to look for suspicious activity, then it becomes far more suspect, I think. And I would say that's another data divide. When data is being used to help people, I think that's very different than when it's being used to categorize or to stigmatize them in certain categories. Another example is, you might have with patient sorting at a hospital, a predictive analytics program might have 1,000 dialysis patients. These are people that have failing kidneys, have the 15 most at risk, and nudge a nephrologist to make an appointment with them. That seems like a good thing, right? But should they be told? Should they be told about that? And must the other people be told that we analyzed you, but you weren't in the 15 most at risk? I mean, it's an interesting question. I think that as we develop better electronic health record systems, we're going to find ways to smooth these information flows. So the bottom line question that I have, and that's just from my book and what I look in the book and in subsequent articles is, are our algorithms embedded in law, or is law going to end up embedded in algorithms? And I think that's a really tough question for us to think about, is do we want to see laws of privacy pretty strictly regulate all the data flows that I talked about? Or ultimately, are these data flows going to be determinative of processes that are like law, right? And to give an example of that, with the social credit scoring system that's being sort of pioneered in China, one of the ideas of it is that if your score based on your credit, on government reports, on your conformity with regime ideals and ideology, if your score drops below a certain level, you won't be allowed to ride trains or planes or do hotel reservations, right? And that is a way where law gets embedded into the algorithms, right? The law of whether you can ride a train or not, or whether you can be in a hotel or not, or that is an algorithmic determination. And I think we have to be very cautious about that. I think whenever these algorithmic determinations are made, they should actually be subject to legal standards and restrictions and requirements. So that's the last, I guess, sort of closing questions. But I'd love to, in a Q&A period, to talk more about any of the particular examples or to answer your questions about any of this stuff. So thank you. Yeah. Thank you. But I'll get a drink first. No? Oh, yeah, go ahead. Yeah. Sorry, I thought your hand was up. Other questions? Yeah. Oh, yeah, yeah.
So I'm wondering about the DNA sites and how they collect data, and then also with like the murder that was just caught using the DNA data.
Oh, great question. Whew, okay. So the DNA sites are really interesting because people send in their information to 23andMe, right? And they think, well, I'm using this to find out more about my health and my relatives, etc. And it turns out that a lot of the data at these sites is not covered by HIPAA because it's not seen as a healthcare provider. And this is the first step that I would take where I think that we've had problematic regulatory arbitrage. And that's a term to designate when a company says it's doing one thing in order to evade the law, but is really doing something else. So for example, with 23andMe, to avoid, for example, having to be a licensed medical provider or to abide by certain other laws of medical licensing, they would say things like, well, to regulators if they inquired, they say, well, this is just for curiosity's sake. We're not diagnosing people, just lay off, don't be so strict on us, etc. And they've won that battle to a large extent. But I think what people didn't understand with 23andMe, or what a lot of folks didn't understand, was that the ultimate business model was not getting people to pay $99 or $199 for some pretty dubious estimates of their likelihood of getting some diseases, right? But was actually gathering one of the largest DNA databases available. And so I think now, with respect to law enforcement, I think we're just going to see a lot more of this stuff because there's just such a pressure to handle cases like this. The question then becomes, how far down does the level of severity go, right? I mean, with this guy seemed like the one of the worst murderers in U.S. history, right? So you can see why people might be quite amenable to using this database in order to find him. Um, at what point will the mission creep toward all unsolved crimes, toward other sorts of things? I don't know. But it's hard for me to imagine how we legislatively get a handle on this right now. I don't know if that's because part of the other thing that's happening with law enforcement is that it's almost as if you have to. It used to be that there was too much information, there was not enough information, and you'd want to try to gather it. And now it's like we're in the reverse, we're like over information overload, and the question is like what to look at. And so I think that something similar is happening with law enforcement. That there's just so many ways of finding of using information to solve crimes that it's hard to see where the courts or the legislature steps in to stop them from using it. So yeah, but I'm sorry I don't have. There's someone named Tennille Brown at University of Utah that's written brilliantly about these DNA databases, and I think also after the BTK killer in Kansas was found in a similar way. So I think that's just going to be the wave of the future of how they find criminals. Yeah. Other. That's, oh yeah. Yeah. Oh sure. Oh yeah.
So you mentioned a lot about how you think Europe is and privacy laws there are going to sort of fix things or make it private. And one of the things I think companies are really good at is making money and evading tax law.
Yes.
So where do you think, or why do you think like GDPR or other privacy laws will be effective, and where do you think the balance between law versus like education of the public to have them stop using products or use different products?
Right, right. I'll start with the second one. I mean, my big worry about telling people to delete Facebook or hashtag delete Facebook or, use DuckDuckGo instead of Google and other things like that. I'm very worried about that because I think that people get a false sense of security because so many sites use things like Google Analytics, or they've got trackers, or they've got Facebook buttons on their page that are somehow, and Facebook does have these shadow profiles of people. And so if you look at the dark ads, the shadow profiles, all those sorts of things, Facebook and Google are really like Equifax, right? And remember that big breach where it's like they have all this information about people and nobody opted into Equifax, right? I didn't say, hey, I want all my information in an Equifax dossier. They just have it. So I think that's part of the problem. I think my big hope with Europe is just that it's the fines. That's all. I mean, I think there'll be enough data protection authorities that will impose big enough fines for violations that will scare them. But you're absolutely right to say that there are so many ways to arbitrage around it. I've been in this huge intellectual battle recently over something called the right of explanation. So in Europe, you have the right not to have a decision made about you in a significant aspect of your life in an entirely automated way, right? So if, for example, you applied for a loan and they said, we put your name in the computer and the computer says no, you would be able to tell them, well, wait a second, that was totally automated. What was the basis of the decision? And they would have to give you some information about the logic of the processing of the data. Now, there are all of these people that are funded by tech companies or otherwise ideologically opposed to forcing explainability in machine learning. And these people are all like, oh, let's find ways to get around this, or let's get people to consent to it, or, the explanation can be really simple, right? That sort of right of explanation was defeated in America by something called reason codes. So if you have a bad credit score, you can demand the explanation for it. They will send you one of 40 reasons codes that are less than 5 words long that are like too many revolving accounts, too few revolving accounts. Too much, like they can just give you these sort of like fake reasons, right? And so that could happen in Europe. No doubt that could happen. But I hope that at least a few of the countries are going to have brave data protection authorities that are going to push a little bit harder and are going to try to stop that sort of a thing. So yeah. So that's but we should definitely talk as well about explainability in machine learning, because that's another talk on some level. But it's also, I think, really critical to the future of. I know it's a lot of CS folks in here, right? And so thinking about how CS develops, that's very important about whether you're up for neural nets or not and things like that. So yeah, sorry. Yeah.
So, it's some of your help thinking about the law, because one of the things that bothers me is not so much the amount of data they have, it's that some of that data is false.
Yeah.
Alex Jones is now being sued by folks that were involved in the Sandy Hook, or victims in the Sandy Hook shooting, where he, on his show, has accused them of being crisis actors and so forth. And they're coming back, their lawsuit back is to say, look, you have the freedom of the press, but the freedom of press doesn't allow you to make false statements.
Yes.
And show reckless disregard for whether the statements you're making are true. Freedom of the press isn't a blanket freedom to say anything in a press-related way. So when you were saying that the response that you might get when you ask people to delete their accounts on us is, well, it's freedom of speech, it's First Amendment. Where in the law is there a guarantee of protection for freedom of speech in those type of cases when the speech is false or when the speech is not corrected to make sure that it's actually saying true things about you?
Yes, I love this question because this is like such a this is the and can I use this board, or is there any way to like get rid of this and then just use the board in the center? Because I want people to be able to see this like fun diagram. Because and before I thank you, great. Because before I diagram it, I'll just say that there's a real issue in terms of I'll wait till this. Thanks. All right. Great. Okay. So to review the bidding here. Okay. All right. Sorry. This is high tech. All right. So, low tech. All right. I know exactly. Oh no. It's the smart chalkboard, the smart board. So we start with to review it. We started with this idea of privacy, right? And then I said, you can try to keep things secret, but remember that a lot of times, or you can try to keep them from saying certain things about you, but then they might claim the First Amendment, right? Then the question said, wait a second, First Amendment does not protect falsity, so false statements are not protected. Okay. So to start with this, I'm going to make this really concrete. Say there's a company say the government passed a law that said you can't create lists of people that have diabetes, okay? And this has actually been done. These lists are for sale for 7 cents to 15 cents a name. List of everybody in America with diabetes or something like that. Or everybody on a certain street with diabetes. So you can see where that's going in terms of anonymity or non-anonymity, right? So they have privacy, and then they say, well, we have a First Amendment right to sell that stuff. And we should be able to have the list. But then the argument is, well, some of it's false, right? There's actually been stories about people that were on the diabetics list that don't have diabetes. Well, then what the company said is, oh, okay, well, we're changing the name of the list. It's no longer the diabetes list. It's the diabetic concerned households list. Okay? Now, why do they say that? They say that because this is defamation law. This is like black letter standard defamation law. But the courts really don't like defamation law in America. They keep trying to cut it down. And one of the ways they cut it down is they say, well, an opinion cannot be proven false. Right? So if I were to say, I think, my opinion is that guy is diabetic concerned because I have a couple of websites that he visited that were about diabetes, so diabetes concerned, okay? But fortunately, although opinion cannot be proven false, and that's on this First Amendment side, if you can prove that an opinion has factual foundations, and the factual foundations are false, then you could go after them in defamation, okay? So this is sort of like this incredible struggle in our legal system between values of free expression and the rights of individuals not to be defamed. And so, for example, in this factual foundation situation, if you could prove that the factual foundations of being diabetic concerned were somehow a falsehood, then you could go after them. But this is just the First Amendment problem. This is your free expression versus privacy problem, right? So this is that one. But then you have to prove damages. So let's say I am the most masochistic data plaintiff imaginable. I go through this entire rigmarole, probably up and down appellate courts 2 or 3 times over 15 years. Then I have to go to prove damages. Then they say, well, how did this hurt you? Did this keep you from getting a job? And I'm like, well, no employer is going to say they didn't hire me because I was part of a diabetic concerned household, right? And so this is a huge problem. Now, in Europe, the proof of damages is much easier. There's a lot of ways in which, for example, people can claim and win damages on the basis of like psychological harm, time spent disputing things, other things like that. And this again is why, looking closely at what's been the most important thing that Trump has done in the first couple of years, or what he's been most committed to, I was going to say regime. The administration is most. The administration has been most committed to getting judges on the bench. Why? Because judges decide things like this or like this, right? It's judges that are going to decide whether, for example, your proof of damages actually is proof of damages or not, right? Often, legislators can change this, but there's a case called Spokio versus Robbins where the court even tried to constitutionalize, or there was risk of the court constitutionalizing immunities for a lot of these data providers. So that's where we are, and we're in this very complicated space, and it's hard to get across in like a soundbite how hard it is, but that's where we are. But I did see a question over here. Was there a question earlier? Oh yeah. So yeah.
So I read an interesting article recently about the United States Agency for International Development. You said working with an African country for like local data management, and so they were trying to decide who was going to manage the data for like a large part of the country, and so instead of like choosing a cheaper local data management firm, they went with like a U.S. based company. So the analysis in the article was that like data is like capital now. It's worth a lot of money, and
Oh
so
yeah.
it was being like outsourced to the United States, which is kind of a new form of potentially like colonialism. So I was wondering if you have anything to say about like that.
The data colonialism thing is very interesting because that's another area where there are some very tough choices to be made. So, for example, like Facebook went to India and had something called Free Basics. And the idea behind Free Basics was we're going to provide you with internet access, you get on the internet, but it's all through Facebook and we decide what you can see and what you can't see. And from a purely utilitarian analysis, that's wonderful, right? You're going to have tens or hundreds of millions of people that have no access to the internet through the incredible charity of Mark Zuckerberg. Now, and by the way, we should get into his charity at some point as well, the charity, but they, through his incredible charity, are bringing them to the internet. But the whole idea of that was that you sort of create this way of shaping tastes, of gathering data, of acclimating people to certain interfaces, so that you are creating this sort of market that you have a deep level of control over. And it reminds me, I imagine it like, imagine if, the deserts were told that we could bring you a pipe from the Great Lakes, but we get to control all of your water, or something like that. I mean, it's one of those things where I think it's tough, and the government of India, and I think a lot of activists said this is not a bargain we should sign up for. And I think that they just quit on Free Basics recently. I think that just a few days ago they quit on that. And so that's where I think that we bring in the philosophy, right? Because from a philosophical perspective, so much of the stuff I read in AI, it's really crude utilitarianism. And it's like, well, if people are better off at time 2 than they were at time 1, we do it. But it's like, if we don't think about the power dynamics that we're entrenching as we try to increase people's station or improve their lots, that's troubling. And also, if we don't allow them to democratically decide if that's how they want to improve their lots, that's important. So the colonial connection is right on. By the way, a lot of right-wing think tanks right now are defending colonialism. They're putting a lot of investment in saying, hey, England and India seems like it made it a lot better or something, and this is very bad, right? I mean, this is very troubling because I think that on the one hand, you can try to tell that sort of historical narrative, but if you're not simultaneously continually acknowledging the types of exclusion, subordination, cruelty that exist to this day, global imbalances that exist to this day, they're not being honest about it. So yeah. Other thoughts, questions? Yeah.
It seems to me, to go back to something we talked about a long time ago, the American counterpart to the Chinese social credit system might be the no-fly list.
Yes.
How would you compare those two? Is one of them acceptable and the other not? Are they both awful? I mean, clearly they're both awful, but...
Yeah. Excellent. No, I'm so glad you mentioned it because I just wrote a little article called Black Box Stigmatic Harms and How to Stop Them. So the no-fly list is a great example. There's a great piece by Margaret Hu called Big Data Blacklisting. And it's about all of these blacklists. And there's not just a no-fly list. There's a no work list. There's a no immigrate list. There's all these no lists out there. And they are riddled with errors, full of errors. And the problem is that, and this goes back to another terrible Supreme Court decision. Okay, there was a case. To give you the history of it, there was this one case from the 60s called Wisconsin versus Constantino, and in that case, a sheriff went out and put out a drunkard list, and the drunkard list had Constantino's name on it, and it said, "She is a drunkard. Do not sell her alcohol," and put it in every liquor store in the county. And the Supreme Court said that is a taking of your reputation. Just as the government can take your land, let's say they put a road across your land, they've got to pay you for that road. If they defame you in that way, they've got to pay you for that defamation, right? You can get damages. About 5 or 6 years later, composition of the court changes a little bit. There's a case called Paul versus Davis, which has a very complicated fact pattern, but the bottom line of it is that only if the government, when it defames you, takes something concrete away from you, only then you can get compensated. Okay? So all of these people that are on the no-fly list that shouldn't be there, all the errors that the government is making within its programs, often with overpaid private contractors who are providing the data, there's no way to get compensation for those errors because it's just a classification. It's seen as just a classification, not as the stigma plus something concrete. So that's where we stand, and I think it is really bad. I mean, I've endorsed a solution called substantive due process. And substantive due process is the types of things that no government can do to its citizens. You just can't do it. So a substantive due process case would be something like prisoners can be married, right? The state can't just tell them you can't be married. Foreign language in schools. In the 1920s, there was a big German scare, and they said we can't teach German in schools. And the Supreme Court said, no, substantively, you have to let people teach their kids German. And there's a line of cases like this, and I think that ultimately maybe the only solution for something like this is to just say you can't, this present whole process offends substantive due process, and we can't do it. So yeah, great question. Oh yeah, I see one back here, and then two. Yeah.
So I've heard that substantive due process, though, doesn't really have much of a constitutional basis, and also it's been used to, I believe, I recall it being used like in the Dred Scott case to justify his being the property owner. How do you justify having that, adopting that doctrine yourself without much support behind it?
Sure. No, I mean, I'm not. I mean, I think that all of these doctrines can be used politically in constructive and destructive ways. I think they can all be used politically, and I think that's part of the recognition. I think part of we are evolving in, I think, law and political science to see the Supreme Court as a certain super legislature with, in many cases, as a super legislature with a certain bounds on its jurisprudence, right? So I think that's where we're going. Yeah, I mean, I would have to confess that you're right to say that. And yeah, given the way that the court has been selected and other aspects of it, you probably wouldn't want to put much hope in it right now. But I do think that it's important to keep some of these doctrines open because if, like, I was just at this conference called the First Amendment in an Age of Inequality, and a lot of the past 10 years of progressive legal scholarship has looked at the First Amendment as a source of a lot of pain and disenfranchisement and empowerment of corporations, right? Like Citizens United. That's a big part of the First Amendment, to say corporations are like people and they get to spend as much as possible in elections and things. But a lot of what the conference was about people trying to use the First Amendment in another direction. For example, to help striking workers. There's ways in which it could be used there. There's ways in which it might be used to stop gerrymandering. It might be seen that if people are gerrymandered into districts that destroy their political representation, that's punishment on their speech as expressed in their voting. So there's many, many creative arguments that you can make, I think, on either side. So that's part of the duality of the con law. But yeah.
I was just thinking about this big picture question that you raised, like, well, when are we going to extract ourselves from a data collection economy and how?
Yeah.
And it raised the regulatory question for me, which is, let's say we were going to take a regulatory response of some kind. I remember there were some debates several years ago around, do you regulate data collection or do you regulate use, or are there appropriate configurations of that? And I'm curious if you've got any big picture thoughts about where regulation is more effective. And here I'm thinking about new categories of data collection that become possible. So frontiers in biometric data collection that gather affective information or mood or stress level information. So we have new frontiers of data collection all the time. Is there a point where we say this type of data we just won't collect, or does it make more sense to say that's going to be tough to regulate? Let's just say these uses we're going to rule out. I don't know if let's see if you have some thoughts on that.
It's really interesting. I mean, I think that being able to say that we're not going to collect certain data is really important. And even preventing people from contracting to allow for certain data to be collected is important. So for example, if the employer says, I want to watch everything that my employees do in the bathroom, right? They might be smoking, they might be doing something bad, etc. They might be converting trade secrets. I need the camera on in the bathroom all the time, right? By and large, that's just illegal, and they can't have you sign a contract where you say, I have the right, but I don't assert the right? And that's a good thing. And I think we're going to find categories like that within this data collection. I think even forms of analysis we might go after. There's a paper out there called Facial Inference of Criminality, and it proposes to say, it says that it can infer your likelihood of being a criminal from just your face, right? Okay, that's the type of analysis that, and what's amazing to me about this paper is that it attracted a firestorm of criticism. The best article is called The New Physiognomy, because it used to be in the 19th century, we had people like Lombroso who said, oh yeah, the criminal has a face where they have like a bulge here, or they have like a weird nose like this, or something like that. And that was the science of criminology in the 19th century. And now we have machine learning people bringing it back saying, well, if we have enough faces, we can tell who's a criminal, who's this, who's that, who's smart, who's not so smart, etc. Right? I think that type of analysis, I would not be upset if it were banned, right? And that's an odd position to take, right? Because in a university, a lot of times people are like, but it's just knowledge, right? We're just trying to understand. But on another level, it's like that sort of analysis of people, it seems to be treating people as things, and it also seems like dangerously consonant with forms of racial science and hierarchy and forms of other forms of subordination that we're very familiar with. So I'd be very worried about it. I think with respect to use, I have a piece in Le Monde Le Monde Diplomatique that's coming out soon that I have the English version where I've tried to say, here's all the uses I want to stop. But I think you've got to have a big list, and you've got to have a lot of enforcement, I think, of stopping use. But stopping certain collection, also requiring erasure, right? The other thing that I think would be really helpful to require erasure of data would be to tell companies, if your database gets breached and you've kept data on people for like 10 or 20 or 30 years without a good reason for why you're keeping it, there are big penalties for that, right? That I think would be another area where, you might be able to incentivize them to just get rid of certain data. But it does raise very interesting questions about, like, do you think that there is your goal sort of like knowledge forever? But I think that's mischaracterizing it, because a lot of this knowledge, as was mentioned in an earlier question, is fake or false or poorly collected or other things like that. So yeah, so I think that would be part of it. I also just think that like the health stuff is going to get so tempting. And I think we really have to try as hard as possible to keep any employers, insurers, banks, landlords from getting access to people's health data. I think that's really critical, because there's so much temptation for an employer, especially who's self-insured, to be like, I don't want somebody that has even a 3% chance of cancer coming on my company, right? And if they were ever able to use that data to keep those people out, it's really unfair and very bad. So we have laws against that right now, but it's hard to enforce them because sometimes this data can be put into other scores. So it becomes hard to find out exactly, like, someone wouldn't tell you, we're not hiring you because you have a 3% chance of cancer. What they would do is they might hire an employability score that somehow has that data in it. And that would be very troubling. So yeah. Other questions? Oh yeah.
Do you expect the stronger privacy regulations in Europe to have a spillover effect in the United States, in sort of the same way that better emission standards in one state for cars might affect things across the country?
Yes, I do. The question was about the whether the Europe laws would change things. Yeah, I mean, you already see that a bit with Facebook, where they're saying we want to give everyone in the world. At first they said we want to give everyone in the world certain forms of profile control that would be that we had to because of Europe, because it's more affordable to just do the same thing for the whole world. Now I think that they're backing away from that, but I think that will be the value of conformity and the value of like a standard, a global standard is good. And if it's that they're the highest standard, that'd be great. That has been happening with health and safety as well in Europe. Because a lot of the U.S. health and safety regulations have been about toxic chemicals, other things like that, have been gutted over the past, especially during the Bush administration and presently. And so they've become the de facto standard in that, and they may become the de facto standard on this stuff too. So yeah. All right. Oh yeah, in the back. Oh, I'm sorry. Yeah, in the back. Yeah. Yeah. Yes.
And it seems like it really does fold into standard records management practice. So, an analog, if you take liability and tort law and look at autonomous vehicles, there has to be some kind of record of what the computer was thinking when it crashed. And it's going to have to be built into systems. And I wonder if that's sort of a context in which you could start demanding of all sorts of corporate decisions. Where we are automating all sorts of corporate decisions in very basic ways without AI yet, but that's coming. But when you automate decisions in a workflow, it's all documented.
Yes.
So it inherently captures the record of what people have said. Of course, people do in their design of systems, they want to have some things readable.
Yeah.
So, but there is a context of capturing records, and as we automate all decision making, we're going to have to leave that the records capture process. I wonder if that's a sort of technical and legal context for right of explanation concepts. They'll be fundamental to AI in the future.
I think that is absolutely the case, and I think that's the question of record keeping to allow an explanation for how the system operated is really critical, and we see that in U.S. law with the consolidated audit trail of securities transactions. You have other laws, the legal entity identifier rulemaking. There's so many laws in particular narrow legal contexts where that's required. Health records you have to tell where you got it from, where you're putting it to, etc. That is important. I will, though, to sort of give the devil his due, I will say that the counter-argument among some of the people in machine learning and really advanced neural networks and other things like that is that they say, well, it's so complicated, there's no way to record everything that's going on within the system. And that's a very interesting question where I need to talk more with the people that are experts on doing this sort of recording, right? And that's where I haven't had a good enough chance to do that, because at some point, it's like you do have to stop the infinite regress of like, the system does something and it's recorded, but then you're recording the recorder, et cetera, things like that. And I think that you're absolutely right to say that like trying to document what exactly was the critical piece of information that led to something happening is very helpful. And it's also gonna be part of autonomous weaponry as well. That's gonna be a huge part. That should be part of a global arms treaty on killer robots, right? Because we really need to have a treaty whereby we can, to the extent this type of autonomous weaponry is in the field, we'll be able to attribute what it did to somebody. And I have a piece actually called Toward a Fourth Law of Robotics, where I say that, Isaac Asimov has his first 3 laws of robotics. I say the fourth law is that a robot's action must be attributable either to a person or to a process within the robot. And I think that's part of this. So yeah. Yes. Yes, and that's also in this new book called Army of One about these autonomous weapon systems. It says that you can't allow machine learning that sort of is like unsupervised learning in the field by a machine learning system in a battlefield context, because we wouldn't be able to reverse engineer what caused it to do something. So that's an argument that's already been put out there by I think one of the leading arms researchers, Paul Scharr. So yeah. Oh yeah. Yes. Oh yeah. Excellent. So this is a great question about keeping governments accountable as they use these automated systems. And I teach a class called Administrative Law, and a lot of what administrative law is about is when an agency makes a rule, like there'll be a statute that'll say certain people will get Social Security disability benefits. And then and it'll say you have to be disabled. And then the rule will be, here are the 57 things that count as disabled. And then there's an adjudication about whether somebody fits into one of those 57 categories, right? And all the administrative rule law is about is trying to make sure that they, as they move from statute to rule to adjudication, that was a process that was understandable and that could be justified. You need to have exactly the same thing whenever automated decisions are made. You have to have the exact rule, the policy documented. You have to have all of those things there. And then you have to have people who can come in and can understand how the decision was made in any individual case. So for example, there were systems in Colorado that were denying a lot of women Medicaid benefits, even though they had breast cancer. And this was before the Affordable Care Act. But at that time, there was a statute that said if you had breast cancer, you automatically got Medicaid benefits, right? And so in that state. And so that was a situation where the computer program was essentially a rulemaking that did not reflect the statute. So you have to be able to have those sorts of post hoc examinations of what's going on. But in general, with the government, like the English example was a really terrible one, and these keep happening. What's bad is that people like Danielle Citron, one of my colleagues at Maryland, she was writing about this stuff in 2006. There was just a book released called Automating Inequality that's on exactly these issues. They keep happening because by and large they happen to powerless people that can't mobilize their support to force a better resolution. And I think that's something that just has to be really looked at more closely as we use these systems, because they can just be used to automate a lot of very damaging decisions. The other decision that was recently was the Australian robo-debt scandal. So Australia had this thing called Centrelink that would just sort of automatically say that people owed money to the government at various times, and it was almost impossible for people to appeal these sorts of things. So I think part of it is too, holding government accountable involves appeals processes, right? So with Social Security disability, you actually have 7 layers of appeal. So you have 7. If they deny you disability, you have 7 chances to get the money from disability insurance. So that's a lot of layers of appeal. For a lot of these automated decisions, I'd be happy with like 1 or 2, but you just don't have it there. So that's really tricky. And I think that's. But ultimately, maybe the answer is that you have something on. If you want a really wild idea, in Taiwan, there's actually 5 branches of government. And one of the branches of the Taiwanese government is called the Control Yuan. And what its goal is to make sure that the other branches are actually operating in accordance with the principles that they say they're operating in accordance with. So it's interesting to think that, like, in our system, that role would be filled by an ombudsperson or a special inspector general at an agency. But inspectors general and ombudsmen have very little power. But if you had a separate co-equal branch of government that could audit the others, that might be an answer, right? And I've tweeted recently about 5 agencies that could enforce algorithmic accountability. So that's an interesting area. And it's true, the American system is so broken because, we've had situations where the inspector general was called into question by the agency, and then we had a special inspector general inspecting the inspector general. So we have to watch out for that situation. But there are ways of building in accountability. So yeah, very good question. Yeah.
I was wondering if you could comment on the role of undergraduate education in preparing scientists, computer engineers, computer scientists, data scientists, programs of computer science, data science at the undergraduate level. Do they have a role to play? How and where to include this kind of preparation in the curriculum?
Yeah, I think the most important thing is to have, and I'll give a really concrete example of this to back myself up, to have case studies that illustrate never events. So in healthcare, like a never event is, say someone goes in to get their left leg amputated and they amputate the right leg, right? Or they leave a big sponge in during surgery, right? And if you do a never event in healthcare, you lose reimbursement, there's a big investigation, there's a malpractice lawsuit, all these sorts of things. And what are the analogs in data science and data practice? And here's one. I just wrote about this example recently. There was a woman who had, on one of her data dossiers, it said that she was a convicted meth dealer. Okay, she was not a convicted meth dealer. Then this dossier was sold to 60 other data broking companies, all of which were creating dossiers and reports on her that were distributed to, when she applied for a dishwasher, credit for a dishwasher, denied, every job denied, being a tenant denied, all these sorts of things. And it took her over 4 years and hundreds of letters and calls and other things to get all these data brokers to get the meth conviction off of her record, right? Now that to me is a never event. And the question is, how could you architect databases in order to avoid something like that? The irony is that, there's a lot of enthusiasm now about like blockchain and distributed ledger technology. But the irony of a lot of that technology is that might put the error in permanently all over, right? If the virtue of this is uncorruptibility and unreversibility, which some people say it is, then it gets everywhere. And what's so funny is like a lot of the blockchain people were like saying, oh, this European GDPR, it can't exist because we have blockchain and they give you people a right of erasure, right? A right to erase certain data. That's in the GDPR in Europe. And I think the response is no, actually the blockchain has to be modified technologically to account for and to allow for different countries' views as to the erasability and reversibility of data entries. And so I think that one of the best things to do, the other thing that I think is really critical, is rather than thinking of legal restraints as something that's just this awful barrier that keeps us from doing what we want to do, to seize upon them and embrace them as a worthy task, worthy of executing, right? And that's something that I hear from a lot of computer science professors is, okay, with that example of Taylor, how would we design the database so that somehow there was a watermark or some sort of connectivity or something that would allow for the instant correction of all the databases that followed on from the corrupted database. So I'm hoping that I worked on trying to develop some case studies for the Council on Big Data Ethics and Society, and I think our website is still up. There's a guy named Jake Metcalf that does different syllabi in the area, and there's a lot of, I think there's a growing number of scholars that are trying to bring it to the undergraduate curriculum and through case studies and through sort of ethical reflection on these scenarios. So, yeah. Yeah, yeah. Oh yes, and I mean, and what's ironic too is, I mean, I guess that has led to this whole branch about like one-shot learning, right? Or there's some sort of like one-shot learning folks that are like, oh, we could learn from a small data set. But I guess that shows also some of the conflict between the statistics community and the machine learning community, right? And maybe teaching that would be a very, I think, pedagogically worthwhile caveat to the competition, right? Or what the competition should do is it should award people, it should create the possibility of giving first place to people who dispute the validity of the competition. Call it the Turing Prize or something, you know. So not the machine should halt, you know, or something. I don't know, but I really do think that would be a way of recognizing the problems here that would help. And I sympathize with your objection, and I think that trying to figure out how to help people do it in the future, or how to make it part of something like continuing computer science education. Like lawyers, we have continuing legal education, and it's not great. If you want to do just sheerly technical law stuff, you could, but there's a lot of stuff that's actually about ethics and like being a responsible lawyer. And I think the professionalization of engineering and computer science needs to advance a little bit more so it has things like that. But yeah, but this was definitely worth working on in the future. Yeah. All right. So I think we're all set. Well, thanks again. Oh, I'm sorry. You know. Okay. Well, thanks again. I appreciate it. I'll talk with you afterwards. Yeah. Thank you. Thanks, Montel.
Yeah. Could we give it up one more time for Dr. Pasquale? Thank you so much for coming and speaking. And thank all of you so much for coming. If there's still food left outside, I don't know if there is, please take it. And If you're interested in Dr. Pasquale's work, he wrote a book, The Black Box Society. Go read it. It's really interesting. He's written many other things. And have a good night, everyone. Thank you so much.